China's modern legal system was imported from civil law tradition countries like Germany, France, and Japan in early of 20th century. The choice was made because of China's own legal tradition. In the past, each dynasty had always compiled a legal code to bind the society. After New China was founded, China's legal system had been influenced by the Soviet Union. Later, when China opens up to the world, many overseas students have brought back more theories from common law tradition countries, such as the United Kingdom, the United States. Today, China's legal system appears to have mixed characters, although civil law lineage is the core. In this video, let's talk about the sources of Chinese laws. From the structure of legal sources, I will explain why China's legal system can so quickly address new issues in social and economic development. Before my introduction to specific sources of China law, please check my previous video, How the Law is Made in China. That video offers you basic understanding of the lawmaking process in China. To better understand the subject matter in this video, I want to quickly mention several key points. First, China does not use federal system, by which the government power are divided the national government and the local government. In China, the local government is subordinate to the central government. China only has one constitution. The law passed by the National Congress is applied nationwide is on the top layer of legal sources. Second, China has 5 levels of administrative structure from county up to central government. The higher level government makes important laws. The lower level government makes less important laws. Third, typically, the law is made and passed by the National Congress, but in certain situations, the Congress may authorize the State Council to make laws. For example, China's VAT law, consumption tax law. Fourth, certain regionals or cities have specific authorization to make laws that can be different from existing laws. For example, the autonomous regions, special economic zones. The last, both the National Congress and the Supreme Court can explain the laws. The one from the National Congress is called legislative interpretation. The one from the Supreme Court is called judicial explanation. The legislative interpretation has the same effect as laws. Judicial explanation is used in guiding judicial practice. In this part, you might notice I use more generic term law to start my introduction. In the next part, the terminology of law will be more specific. Now, let's take a look at specific sources of law. The first one is the Constitution. Like most of countries, the Constitution is the highest law in the land. The Constitution can only be revised, interpreted by the National Congress. However, in China's judicial practice, the Constitution has never been cited to the court decisions. In China, it's not the court to decide whether a law is constitutional that power is authorized to the National Congress. The second legal source is the law. The authority to make a law is in the hand of the National Congress. Here, the terminology law has specific meaning. It particularly refers to laws made and passed by the National Congress. And according to China law, only certain subject matters can be made into laws. Here is the list. Matters related to state sovereignty, governmental structure, for example, how to set up a court, the government branch, the local congress, etc. Basic policies for autonomous regions, special economic zones, and autonomous policies for grassroots, crimes, and corresponding punishment, basic civil rights, taxes and how to levy taxes, expropriation and confiscation of personal property, basic policies for civil matters, fundamental economic policies, judicial and actual proceedings. Any matters out of this list can go through that strict process in lawmaking process. In certain situations, the National Congress may authorize the State Council to make laws. However, such authorization has limitation in time and in subject matters. The third source of law is the administrative rules. In general, the administrative rules means rules made by the State Council to implement the laws passed by the National Congress. To better understand what the administrative rules are in China's legal source structure, you can compare it with the Code of Federal Rules in the United States. The administrative rules may appear in different names. For example, measures, implementation rules, announcements, orders, etc. Many sectoral regulations may have similar names in Chinese. To find out whether one is the administrative rules, you need to check who is the authority to make that rule. Unfortunately, China has not codified or compiled its administrative rules as well as the laws on an official publication. So sometimes it's extremely hard to find the laws and rules through official resources. Another source of law from the central government is the sectoral regulations. These are rules promulgated by different departments or agencies of the State Council to implement the laws and the administrative rules. There are huge numbers of sectoral regulations because many laws and administrative rules have to be specified or detailed by different regulatory authorities. The provisions in the laws or the administrative rules sometimes often use very general language, which is lack of clarification. For example, the Central Bank of China, POC, may issue rules in implementing China's monetary and financial policies. At the local level, the local Congress can make local regulations, which is a sub-level of legal sources to the administrative laws. Here, local regulations is a more generic term to describe the regulations made by various levels of local Congress, including city Congress and provincial Congress. In certain provincials, autonomous regions, there are some autonomous areas governed by ethnic minorities. The autonomous regions and areas have special lawmaking power to meet the particular needs for ethnic minorities based on their own traditions and cultures. Autonomous regulations or separate regulations may be different from the laws, the administrative rules, and local regulations, as long as they do not violate the basic principles defined by the laws, the administrative rules. Local regulations, autonomous or separate regulations, are only applicable to their own jurisdictions. They do not have overflow effect to other jurisdictions. Similar to sectoral regulations, local governmental agencies can also make rules called local sectoral regulations. Local sectoral regulations are made to implement laws, administrative regulations, local regulations for local administrative matters. In China, special economic zones are some cities or areas with special missions to implementing China's open-up policies as economic development laboratories. For certain matters, the special economic zones are authorized to make new regulations for novel matters in the special economic zones for testing and experimental purpose. When a regulation has become mature, the experience may be extended nationwide or to other cities, provinces. Another important legal source in China is the international law. Regarding the international law, it is questioned about how to domesticate into China's domestic legal system. China takes different approaches to domesticate an international law based on the nature of international law in question. The first approach is directly to apply international law into domestic cases. This approach is used in international private law. For example, in China, the court can directly apply United Nations Convention on Contracts for International Sales of Goods to specific cases. The second approach is to create a domestic law to implement the international law. This approach more often happens through the international public law. For example, China uses the United Nations Convention on the Territorial Sea and contiguous zones to create its own law in that area. The third approach mixes the first two, say, to incorporate international law into an existing domestic law in order to meet the international law standard. For example, after China's entry into WTO, China had revised its copyright law to meet the requirements of international law to which China is a party. The final one on the list of China's legal sources is the leading case. China's legal system essentially follows civil law tradition, but as of 2015, China has started to incorporate common law influence into its judicial practice by publishing leading cases. The legal practitioner has to follow leading cases, particularly in education matters. However, China's leading case practice in no means is equivalent to case law in common law system. Leading case practice does not create law, but provides guidance in a judicial practice. Its very purpose is to avoid situations where the same facts lead to different outcomes by different courts. Strictly, the lead case should not be treated as a legal source in China. After the introduction to each source of laws, we now know China's legal sources exist at different government levels. It might be a little bit more complex than federalism, where federal and state law coexist and where the laws only come from the Congress. In China, the sources of China law come from multiple authorities and exist in more than two layers. Because of this fact, the question is, which one prevails the other whenever there is a conflict in legal application? This brings out our next discussion, how to apply the laws and the regulations in China. In general, the rule of legal application follows hierarchy of legal authorities. Let's use this authority pyramid infographic to explain. The easier way to understand which one has higher authority than the other is to look at who makes the law. So here, the local prefecture city regulation is at the bottom in the pyramid. From there to province and all the way up to central government. The higher level lawmaker is at, the high authority the law or a regulation shall have. So, the prefecture city regulation should defer to provincial regulation. The provincial regulations should defer to the administrative rules, and the administrative rules should defer to laws and the constitution. In China, district, county government is the grassroots government. You may notice grassroots government is not listed in this authority pyramid. This is because the grassroots Congress does not have power to make laws. For laws straightly lined up on the authority pyramid, it is easy to understand which one prevails the other. However, things are not always so straightforward. For laws not on a straight line, it could be confusing. For example, you might presume that sectoral regulations from the central government should prevail laws from the local government. But that is not how it works. In addition to examining the hierarchy of lawmaking authorities, there are rules to resolve issues in the legal application. So next, let's talk about some special rules for legal applications. To help you understand better, I separate those rules to two groups. The first group is for those rules made by the different authorities. The second group is for rules made by the same authority. There are three rules in the first group. First, between autonomous regulations, separate regulations, and local regulations, administrative rules, and laws. Autonomous regulations, separate regulations are only effective in the autonomous prefectures if they alter the provisions of local regulations, administrative rules, and laws. This is because many autonomous regulations, separate regulations, are made to meet particular needs of different cultures and traditions of ethnic minorities. It also means ethnic minorities could have their own law to run their government. The second rule, as I mentioned previously, special economic zones as economic development laboratories can make laws for novel matters. Between the local regulations made in special economic zones and local regulations, administrative rules, and laws, the regulations made in special economic zones are only applicable within special economic zone. This is similar to the effect of autonomous regulations and separate regulations. The difference is special economic zones regulations have opportunities to extend to other regions or even to the whole country if the new regulations are good for the country or for other regions. The most confusing part is the authorities between different sectoral regulations. So, the last rule in the first group of legal application is about the relationship between the different sectoral regulations. Although the central government has higher authority than local governments, in terms of sectoral regulations, China law says the sectoral regulations from the central government and the local government have the same effect as long as they are applied to their own industrial sectors. So here, it is particularly important to know that the local sectoral regulations are not subordinate to the sectoral regulations from the central government in general. The second group of rules for legal application are set for laws made by the same authority. For laws made by the same authority, the principle is the special law prevails the general law, and the new law prevails the old law. So, what is the general law? The general law means a law that sets general principles with no detailed implementation provisions for a legal matter. The special law means more detailed provisions to address specific legal matters. For example, the contract law is the special law corresponding to the general principles of civil law, and the provisions relating to contract in the civil law is a general law. Between the general law and the special law, it is about relativity to the subject matter. Between the new law and the old law, it is about relativity to the time when the law is made. Typically, the new law prevails the old law unless the law of retroactivity indicates otherwise. The third law of legal application in the second group is the retroactivity. Generally, the new law typically does not have a retroactive effect unless a law in question sets up a special provision of its retroactivity. For example, in old marital law, it provided rules how to recognize marital relationship in fact happened before new law and after new law. The final question about legal application in resolving issues of conflicting laws is which authority to decide which law prevails the other. China does not have a constitutional authority to work on conflict law issue but relied on a set of rules to decide this issue. There are 4 rules for which authority to decide the conflicting law issue in legal application. First, if there is a conflict between the new law and the old law, it is the Standing Committee of National Congress to decide which one to prevail. Second, if there is a conflict between the new general rule and the old special rule in area of administrative rules, it is the State Council who to decide which one prevails. Third, the conflict between local regulations and sectoral regulations. This has 3 sub-rules. First, between the new general rule and the old special rule made by the same authority, it is the authority who made the rule to decide which one to prevail. Second, between a local regulation and a sectoral regulation. First, the State Council has to provide opinions which one to prevail. If the State Council decides to use local regulations, the State Council must make that decision. If the State Council decides to use the sectoral regulation, then it has to submit it to the Standing Committee of the National Congress to make the decision. Third, the conflict between different sectoral regulations. Between a sectoral regulation and a local sectoral regulation, it is up to the State Council to make a decision which one prevails. The last rule for which authority to decide the conflicting law issue is for issue between a law and a regulation the National Congress has authorized the State Council to make. In this case, it is the National Congress to make the decision which one prevails. In China, party policies are very important to guide China's social development. The question is, are party policies laws? The answer is no. The party policies are not laws. They do not have binding effect for any individuals, organization, except party members. People might argue that CCP is a ruling party and CCP sets up all rules for China. That is not accurate. It is true that CCP has been the ruling party and CCP's policies are especially important for China's social and economic development. But a pure CCP policy is not a law. To become a law, CCP has to go through lawmaking process. And if a party policy has been converted to a law, a rule, a regulation, then the interpretation of that policy must follow legal theory to interpret. As a matter of fact, CCP policies mostly are guidance and general policies in China's social and economic development. They have little value in legal application. In practice, if a CCP policy needs to become a law, a regulation, a rule, it must be issued through a government body. CCP cannot act alone to make a law. From what I have introduced here, you may get some ideas where to find China laws, the hierarchy of the authority of each legal source, and how to apply rules to specific situations. Before I finish this video, I would like to make one final evaluation for China's legal system from my own perspective. China law is a unique system that could quickly adapt to the new situation for the social and economic development. China could quickly handle the new issues because of the flexibility in its lawmaking process. First, China differentiates lawmaking process based on its importance. The most important law must go through a strict procedure to pass it. The less important laws can go through less strict procedure. Second, for certain matters, the National Congress can authorize the government to make administrative rules, which does not require to follow strict rules in lawmaking process. Third, the administrative authorities and local governments also have power to make certain rules, as long as those rules do not conflict laws and rules from higher authorities. 4. As the economic laboratories, special economic zones could make new regulations different from the laws and apply in the special economic zones. If that regulation works, it could be adopted by other regions or be upgraded to the law. In China, a lot of rules and regulations do not have to go through the National Congress. That is the very reason why China can quickly find legal solutions from government level to resolve new issues in its fast economic and social development. Certainly, this quick adaptation have created some problems. For example, the changes of laws happen too often. Sometimes it's extremely difficult for people to follow. Also, allowing too many authorities to make rules creates the inconsistency in constitutionality. People might criticize China does not have a rule of law. That criticism certainly is biased. In my opinion, without a rule of law, China's social and economic development could be very messy, because we are talking about a country with 1.4 billion population. China's successful of rapid development in the past 40 years has proved that China does have and has to follow the rule of law in developing the society. Without that, China's development will not go so smooth. As a matter of fact, for a long time, to embrace of rule of law is a core policy for China's social and economic development. This is all that I want to say in this video. Hopefully, you could get something useful from my video. If you have any question, comments, suggestion, please leave it in the comment area. Again, my name is Jungyun Zhang. If you are interested in my video, please subscribe my channel. If you want to discuss China law issues with me in person, please contact me through my social media or website. Thank you for watching and see you in next video.